You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Federal agencies play a central role in shaping how employment-related privacy, fairness, and safety obligations are defined and enforced in the United States. Each agency has a unique jurisdiction, but together they create a framework that touches nearly every aspect of workplace rights and responsibilities. From protecting personal data and ensuring safe working conditions to prohibiting discrimination and overseeing fair labor practices, these agencies collectively balance the interests of employers and employees. Understanding their roles helps organizations anticipate compliance requirements and align internal policies with federal expectations. Employees, in turn, benefit from having multiple avenues of protection, whether the issue involves privacy and health records, unfair surveillance, or unsafe work environments. This interwoven system reflects a belief that workplaces should not only be productive, but also fair, transparent, and safe spaces for individuals to earn a living. The Federal Trade Commission is not often the first agency that comes to mind in employment contexts, but its authority under Section 5 of the Federal Trade Commission Act extends to employment-facing representations. If an employer makes promises about how it will handle employee data, such as pledging that it will not monitor personal email or that it will safeguard payroll information, the FTC can hold the company accountable if those statements prove deceptive. Section 5 prohibits unfair or deceptive acts in commerce, and courts have recognized that misleading employees about data handling can fall into this scope. This authority reinforces the importance of transparency, making sure that employers live up to the claims they make about workforce data. The FTC also applies its unfairness authority to data security and workforce systems. Employers maintain sensitive employee data ranging from Social Security numbers to medical leave records, and failure to secure these systems can create substantial risk. The FTC has pursued actions where poor security practices left employee information exposed, treating them as unfair business practices. For example, storing unencrypted personnel files on publicly accessible servers would be seen as unreasonable given the risks involved. The unfairness standard focuses on whether the harm to employees could have been avoided with reasonable safeguards and whether that harm outweighs any benefits. In practice, this means employers must design human resources and payroll systems with the same diligence they apply to customer-facing systems. The Department of Labor enforces wage-hour laws that require employers to keep accurate payroll records, but confidentiality boundaries also matter. Records must be sufficient to demonstrate compliance with minimum wage and overtime laws, yet employers must ensure these documents are not misused. For instance, payroll records may contain Social Security numbers, home addresses, or bank account details. The department expects employers to manage these records securely and disclose them only when required. Failure to protect wage-hour documentation not only risks data breaches, but can also complicate compliance investigations. Thus, record-keeping obligations are paired with an expectation of privacy and confidentiality to maintain worker trust. The Family and Medical Leave Act, also under the Department of Labor, creates additional privacy obligations. Employers must maintain medical certifications and related documents in confidential files, separate from general personnel records. Access to these records should be strictly limited, reflecting the sensitive nature of health-related information. For example, if an employee provides medical documentation to support leave for a serious health condition, supervisors should only know about the approval of leave, not the details of the diagnosis. This confidentiality reinforces dignity and fairness while still enabling the employer to comply with leave obligations. The department emphasizes that mishandling these records undermines both legal compliance and employee trust. The Equal Employment Opportunity Commission serves as the principal enforcer of Title VII of the Civil Rights Act, which prohibits discrimination in employment. Privacy intersects with this mandate when data collection or monitoring practices disproportionately affect certain groups. For example, surveillance systems that penalize workers for hairstyle choices could have discriminatory impacts on employees of particular racial backgrounds. The EEOC ensures that such policies are scrutinized and, if necessary, corrected. By framing workplace privacy within the broader lens of equal opportunity, the Commission reinforces the principle that data and monitoring should not become tools of exclusion or bias in employment decisions. In recent years, the EEOC has also issued guidance on algorithmic fairness in hiring. As employers increasingly adopt automated hiring tools, questions have arisen about whether these systems unintentionally discriminate. Algorithms trained on biased data can perpetuate disparities in hiring outcomes. The EEOC warns employers that reliance on such tools does not absolve them of responsibility. For instance, if an algorithm disproportionately screens out women or older workers, the employer may still be liable for discrimination. Employers are expected to test their tools, monitor outcomes, and ensure that technology supports fairness rather than undermines it. The Americans with Disabilities Act falls within EEOC enforcement and carries specific requirements for medical data. Employers must treat employee medical records as confidential and keep them separate from general files. This includes information collected during pre-employment medical exams or voluntary wellness programs. For example, if a candidate undergoes a post-offer medical assessment, the results must not be shared with supervisors except to confirm the ability to perform essential job functions. Protecting medical data under the ADA ensures that health information is not misused to deny opportunities or to stigmatize employees with disabilities. The Genetic Information Non-Discrimination Act is another area of EEOC jurisdiction. This law prohibits employers from requesting, purchasing, or using genetic information in employment decisions. The scope is broad, covering not only genetic test results but also family medical histories. For example, an employer cannot ask a candidate whether cancer runs in their family. By enforcing GINA, the EEOC prevents genetic data from becoming a factor in hiring, firing, or promotions. This protection is forward-looking, recognizing the growing role of genetic science and preventing employers from exploiting sensitive information about predispositions to illness. The National Labor Relations Board focuses on protecting employees' rights to engage in concerted activity, such as discussing wages or working conditions. Privacy concerns arise when surveillance or monitoring interferes with these rights. For instance, if an employer uses monitoring tools to track conversations about union organizing, the NLRB may find such surveillance unlawful. The board views privacy not only as a matter of dignity, but also as essential to collective employee action. Employers must design monitoring systems with care to avoid infringing on protected activities that underpin the balance of power in the workplace. Social media has also come under the NLRB's scrutiny. Workplace policies that prohibit employees from discussing workplace issues online may infringe on Section 7 rights. For example, a blanket rule banning negative comments about the company on social platforms could unlawfully restrict employees from discussing pay or working conditions. The board evaluates whether policies or disciplinary actions create a chilling effect on protected activity. In this way, the NLRB extends privacy and freedom of expression concepts into the digital domain, ensuring that employee rights keep pace with evolving communication tools. The Occupational Safety and Health Administration plays a vital role in balancing transparency and privacy when it comes to workplace safety records. Injury and illness logs must be maintained, but not all details are open to general access. Employers are expected to protect sensitive medical details while still providing enough information to support safety programs and regulatory oversight. For example, summaries of injuries may be posted for employees, but detailed records should remain confidential. This balance allows organizations to promote safety awareness without compromising individual privacy. Medical surveillance is another area of OSHA oversight. In industries where exposure to hazardous substances requires ongoing medical monitoring, confidentiality is essential. Employers must ensure that test results and medical records from surveillance programs are kept secure and not used for unrelated purposes. For example, periodic lung function tests for employees exposed to dust should inform safety programs but should not influence promotion decisions. By enforcing confidentiality in safety programs, OSHA protects both health outcomes and employment fairness. Interagency coordination is a less visible but crucial feature of federal workplace oversight. Agencies often refer cases to one another when overlapping jurisdiction arises. For instance, the FTC may refer deceptive data handling practices to the Department of Labor if employment law implications exist. Similarly, the EEOC may coordinate with OSHA if discrimination issues intersect with workplace safety. These collaborations prevent gaps and ensure that issues are addressed from multiple perspectives. Coordination also reflects the recognition that modern workplace challenges are interconnected, requiring agencies to share expertise and align enforcement strategies. Finally, understanding the administrative procedures these agencies follow helps employers and employees navigate investigations. Most agencies begin with a charge or complaint, followed by investigation through document requests, interviews, or site visits. If violations are found, resolution may involve hearings, settlements, or formal orders. Employers should be aware that these processes are not optional and carry binding authority. For employees, the procedures provide structured avenues to raise concerns and seek remedies. The administrative frameworks emphasize fairness, giving both sides opportunities to present evidence while ensuring that agency missions are upheld. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. When federal agencies investigate workplace practices, they rely on a variety of tools designed to uncover the truth and enforce compliance. These tools include subpoenas, formal requests for information, and on-site inspections. A subpoena compels the production of documents or testimony, while information requests often seek payroll records, personnel files, or monitoring policies. On-site inspections allow agencies to directly observe workplace conditions, whether for safety, data handling, or compliance with wage laws. For example, OSHA inspectors may tour a factory floor to review safety protocols, while the EEOC might request access to hiring algorithms and related documentation. These powers emphasize the seriousness of federal oversight and the expectation that employers maintain readiness for scrutiny. Proactive compliance makes inspections smoother and demonstrates good faith, whereas obstruction or lack of preparation can intensify penalties and reputational damage. Remedies and sanctions vary depending on the agency and the type of violation. The Federal Trade Commission often uses consent orders requiring businesses to change practices, coupled with ongoing reporting obligations. Civil penalties may apply when violations are willful or repeated, creating significant financial consequences. The Department of Labor can order reinstatement of terminated employees or award back pay for wage violations. The EEOC may secure damages for victims of discrimination, while the NLRB can require employers to reinstate workers penalized for union activity. Remedies are not only punitive but also corrective, aimed at restoring fairness and deterring future misconduct. Employers must recognize that compliance failures can have both immediate and lasting impacts on organizational stability and public perception. Compliance programs are central to avoiding enforcement actions. Agencies consistently emphasize the importance of documented policies, workforce training, and internal controls. For example, the FTC expects companies to implement written data security policies and conduct risk assessments of human resources systems. The Department of Labor expects clear wage-hour documentation and training for payroll staff. The EEOC stresses ongoing education around discrimination and bias. By embedding compliance into everyday processes, employers reduce the chance of violations and demonstrate proactive governance. In effect, a well-designed compliance program becomes both a shield and a compass, protecting the company from liability while guiding ethical behavior across the workforce. Whistleblower protections are another major area of oversight, particularly under OSHA but also supported by other statutes. Employees who raise concerns about safety, discrimination, or fraud must be protected from retaliation. Federal law requires that complaints be investigated promptly and that retaliation be addressed with serious consequences. For example, if a worker reports unsafe conditions and is subsequently demoted, OSHA can pursue remedies, including reinstatement and back pay. Whistleblower systems encourage internal reporting, allowing employers to fix issues before they escalate into larger violations. Confidentiality and anti-retaliation commitments create trust, showing employees that speaking up is not a risk, but a protected right. Agencies also require employers to provide notice of rights through postings and reports. Posters in the workplace inform employees of their rights under labor, safety, and anti-discrimination laws. Employers must also file reports, such as OSHA injury logs or EEOC workforce demographic data, to maintain accountability. These obligations ensure that employees have direct knowledge of their rights and that regulators receive ongoing visibility into workplace trends. Failure to meet posting or reporting duties can itself result in sanctions, even if no substantive violation is found. Transparency and accessibility are key goals of these requirements, enabling employees to be informed participants in workplace governance. Data retention obligations further shape compliance practices. Agencies expect employers to retain payroll, safety, benefits, and personnel records for specific periods. For example, wage hour records must typically be kept for 3 years, while certain safety records may need to be retained for 5 years or longer. These requirements ensure that records are available for investigations and legal proceedings. Employers must balance these obligations with privacy concerns by securing records and ensuring they are not used for purposes beyond compliance. Clear retention schedules aligned with federal mandates help prevent both under-retention, which risks penalties, and over-retention, which increases privacy risks. Vendor oversight is an increasingly important element of compliance. Many employers use third-party vendors to process payroll, manage benefits, or handle applicant tracking systems. Agencies expect employers to remain accountable for vendor practices, meaning contracts must include data security, privacy, and compliance obligations. For instance, if a payroll vendor exposes employee Social Security numbers due to weak security, the employer remains responsible for the breach. Oversight may include audits, contractual assurances, and ongoing monitoring of vendor performance. In today's interconnected workplace, compliance extends beyond the organization's walls to its partners and service providers. Automated hiring tools bring both opportunities and risks, making governance essential. The EEOC has warned that employers remain responsible for ensuring algorithmic systems do not introduce discrimination. Compliance programs must therefore include regular testing, audits, and adjustments to algorithms. For example, if a tool consistently rejects applicants from a protected group, the employer must intervene and correct the process. Transparency with applicants about the use of automated systems also builds trust and reduces perceptions of bias. Employers that embrace oversight in this area not only comply with regulations, but also enhance fairness and inclusivity in hiring practices. The NLRB also expects employers to periodically review monitoring and social media policies. A policy that seems neutral on its face may still infringe on employees' rights to discuss workplace conditions. For example, prohibiting all negative comments about the company could be interpreted as restricting protected concerted activity. Regular review ensures that policies evolve with case law and board decisions, reducing the risk of enforcement actions. Employers should evaluate not only what monitoring occurs, but how the associated policies are worded, as the language itself can create compliance problems. For human resources systems, the FTC expects baseline security standards to be in place. These include encryption of sensitive data, role-based access controls, and monitoring for unauthorized access. Breaches involving HR data can trigger both enforcement and reputational consequences, as employees often view workplace data as highly personal. Meeting these security baselines shows regulators that the employer takes its obligations seriously. For employees, it reinforces confidence that their information is respected and protected against misuse. Security expectations are not static, and employers must adapt as new threats and technologies emerge. Complaint handling processes differ by agency, but all require timely and structured responses. For example, EEOC complaints generally must be investigated within a defined period, often followed by conciliation or litigation. OSHA complaints may result in immediate inspections, while NLRB charges can proceed to hearings if not resolved. Employers should establish internal workflows to track complaints, meet deadlines, and ensure consistent handling. Delay or mishandling can escalate problems and demonstrate non-compliance. Efficient complaint management not only meets regulatory expectations but also builds trust with employees who seek resolution. Multi-venue litigation is another challenge employers face. A dispute may begin in an administrative forum but later move to federal court. For instance, an EEOC charge of discrimination could lead to a lawsuit seeking damages. Employers must be prepared to manage cases across multiple venues, aligning legal strategy while complying with procedural rules in each. Coordinated litigation management prevents contradictory outcomes and ensures resources are deployed effectively. This requires collaboration between in-house counsel, external law firms, and compliance officers to keep cases aligned across forums. Settlements often involve more than financial payments. Agencies may impose compliance monitoring, require periodic reporting, or appoint independent assessors to verify progress. For example, an FTC settlement may require ongoing audits of data security practices for 20 years. These measures ensure that employers not only correct past violations, but also prevent recurrence. Compliance monitoring is an ongoing obligation, demonstrating to regulators and employees alike that improvements are real and sustainable. Employers must treat these commitments as integral to operations rather than temporary burdens. Board and executive oversight ties agency expectations to enterprise governance. Regulators increasingly expect senior leadership to be engaged in compliance, not leaving it solely to legal or HR departments. Boards may be required to receive regular updates on privacy, safety, or discrimination risks, while executives are expected to champion compliance culture. This top-level attention demonstrates accountability and helps ensure that compliance is integrated into strategic decisions. For employees, visible leadership involvement reinforces the seriousness of workplace rights and protections, making compliance a shared organizational value. Federal agencies, therefore, operate not in isolation but as complementary guardians of workplace fairness, privacy, and safety. Through investigations, remedies, compliance programs, and oversight requirements, they weave a web of accountability that shapes how organizations operate. Employers must respond with thoughtful policies, effective training, and transparent practices, while employees benefit from clear rights and protections. By understanding the roles of the FTC, DOL, EEOC, NLRB, and OSHA, organizations can move beyond reactive compliance to proactive governance, building workplaces that are both lawful and trustworthy. This synthesis of mandates illustrates that federal oversight is not only about preventing harm, but also about fostering fairness, dignity, and respect in the modern workplace. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.